Senate will come to order. Mr. Carpenter, please call the roll.
Senators Aguilar, Baumgardner, Cook, Coram, Court,
Absent.
Crowder, Donovan, Finberg, Fields, Garcia, Gardner, Guzman, Hill, Holbert, John, Jones,
He's out. Excused.
Kagan, Kafalis, Kerr, Lambert, Lumberg, Marble,
Oh, excused.
Martinez Jimenez, Merrifield, Moreno, Neville, Priola, Scott, Smallwood, Sonnenberg, Tate, Todd, Williams, Zinzinger, Court,
We're good.
Mr. President.
Here. With 33 present, 0 absent, 2 excused, we have a quorum. Senator Fields, please come and lead us in the pledge.
Good morning, Mr. President, colleagues, and Chambers guests. Please join me for the pledge. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Approval of the journal, Senator Finberg.
Thank you, Mr. President. I move that the reading of the journal of Friday, April 6th, 2018 be dispensed with, and that the journal be approved as corrected by the Secretary.
You have heard the motion. Is there any objection? Seeing none, the motion is adopted. Senate Services.
Correctly re-engrossed, Senate Bill 86 and 158, correctly re-revised, House Bill 1132, 1237, 1259, correctly enrolled, Senate Bill 55 and 169.
Message from the House.
The House has postponed indefinitely, Senate Bill 122, the bill is returned herewith.
General Orders, second reading of bills. Senator Sonnenberg.
Thank you, Mr. President. I move the Senate now resolve itself in the Committee of the Whole for the purpose of general order, second reading of bills.
The motion before the body is for the Senate to resolve itself from the Committee of the Whole for consideration of the general order, second reading of bills calendar. All those in favor say aye. All opposed, no. The ayes have it. The Senate will resolve itself from the Committee of the Whole for consideration of the general orders, second reading of bills calendar. Senator Sonnenberg will take the chair.
Committee will come to order. Court rule is relaxed. Mr. Majority Leader.
Thank you, Mr. Chairman. At the sponsor's request, I move to lay over Senate Bill 204 to Friday, April 20th.
Question before us is to lay over Senate Bill 204 to Friday the 20th. All in favor say aye.
Aye.
All those opposed say no. The ayes have it. Senate Bill 204 will be laid over till Friday, April 20th. Mr. Majority Leader.
Thank you, Mr. Chairman. I move Senate Bill 206 to the Committee on Appropriations.
Question before us is to move Senate Bill 206, Committee on Appropriations. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. Senate Bill 206 is moved to appropriations. Mr. Majority Leader.
Thank you, Mr. Chairman. I move to lay over Senate Bill 43 to follow House Bill 1253.
Question before us is to lay over Senate Bill 43 to follow House Bill 1253. All in favor say aye.
Aye.
All those opposed say no. The ayes have it. Senate Bill 43 will lay over to after House Bill 1253. Mr. Carpenter, please read the title to House Bill 1253.
House Bill 1253 by Representatives Lee and Harrod and Senator Gardner concerning implementation of recommendations of the Committee on Legal Services in connection with the legislative review of rules of state agencies.
Senator Gardner.
Thank you, Mr. Chair. I move House Bill 18-1253 and the report of the Committee on Legal Services.
Seeing no discussion on the report from Committee of Legal Services, all in favor of the adoption of that committee report signify by saying aye. All those opposed say no. The ayes have it. The Legal Services Committee report is adopted. To the bill, Senator Gardner.
Thank you. Members, the committee report you just adopted made 3 amendments to the Rule Review Bill, which is House Bill 1253, to account for things that were picked up over the course of the session that were rules that we were not going to extend, but we, as policy matters, decided to do so. That's what was done in the committee report that you just voted aye on. And as you know, the annual Rule Review Bill extends regulations that are within the grant of legislative authority. I ask for an aye vote.
Seeing no further discussion, the question before us is the adoption of House Bill 1253. All in favor say aye. All those opposed say no. The ayes have it. House Bill 1253 is adopted. Mr. Carpenter, please read the title to Senate Bill 43.
Senate Bill 43 by Senator Grantham and Representative Lundin concerning the legal effects that the rejection by the Senate of an individual nominated by the governor for appointment to state office have on the subsequent nomination or temporary appointment of the same individual to or holdover of the individual in the same state office.
Mr. President.
Thank you, Mr. President. I move Senate Bill 43 and ask for an aye vote.
There is an amendment on the desk. Mr. Carpenter, please read amendment L013.
Amendment L013, Senate Bill 43 by Senator Garcia.
Mr. Minority Leader.
Thank you, Mr. Chairman. And as I discussed the other day, this amendment, good amendment.
Still need to move it, Mr. Minority
I
Leader.
thought I moved it the other day. Remove it.
We have to move it again. It's L013.
I move L013.
Thank you. Please continue.
Thank you, Mr. Chairman. And just to refresh your memory, as I talked about last week, the importance of this amendment, L013 would help ensure some protections for veterans, especially those who are disabled. We talked about the importance of that, especially making sure that there wasn't a discriminatory practice. I know some might think on the face value that wouldn't happen, but I was at an event last night in which I was very happy to see that the paralyzed have the Association for Paralyzed American Veterans and the Disabled American Veterans, DAV. And I think as we think about adding those protections for veterans to ensure that they have the opportunity to serve on boards and commissions, this would ensure that protection. I'd ask for an aye vote.
Mr. President.
Thank you, Mr. Chair, and I'll ask for a no vote.
Seeing no further discussion, the question before us is the adoption of Amendment L013. All those in favor say aye. Aye. All those opposed say no. The noes have it. L013 is lost. Please read, Mr. Carpenter, please read, there is an amendment on desk. Please read Amendment L017.
Amendment L017.
Thank you, Mr. Chair. Members, this is probably the simplest amendment. Oh, yes, I would like to move Amendment L017.
Please proceed.
This is probably the simplest amendment that I have ever run because it strikes one word. It strikes the word legally. It is on page 4, line 20, when it says the rejected individual is deemed legally unfit for and ineligible to hold the office. The reason why I think this is really important is that we get at the same level of protection, you get the same level of emphasis in this legislation without using that word legally unfit. You could just say unfit and ineligible. But by stating the word legally unfit, I think we are opening up the door to something which is much greater. For example, if you are to just Google that term, legally unfit, what comes up are court cases where parents have been deemed legally unfit and they had their children taken from them. Not only that, but if this body deems an individual legally unfit, that could have consequences on their employment in the future. Not only that, it's the kind of thing that could be picked up in a custody case in which there are children involved. Deeming a person legally unfit just because they are unqualified or ineligible or unfit to serve on a board could have consequences that go far beyond what I think the intent of this legislation is, and I don't think it's necessary. You get at the exact same thing that you need to get in this legislation without using that word legally unfit. I think the consequences for people and their careers, their livelihoods, their future employment prospects is just too great. And so this is a very, very simple amendment. It's an easy fix just by striking that one word legally. I don't think it changes the intent of the legislation, and I would encourage an aye vote.
Mr. President.
Thank you, Mr. Chair, and I ask for a no vote.
Seeing no further discussion, the question before us is the adoption of Amendment L017. All those in favor say aye. All those opposed say no. The noes have it. L017 is lost. Mr. Carpenter, please read Amendment L003.
Amendment L003, Senate Bill 43 by Senator Aguilar. Amendment Print Bill, page 4, line 16, strike novels.
Senator Aguilar.
Thank you, Mr. Chair. I move Amendment L003.
Please proceed.
Thank you, Mr. Chair. This actually just specifies that if the rejection may be due to race, the rule does not apply. And members, we know that many times people are discriminated against because of their race, and we want to be sure that if there's reason for the governor to believe that that may have been the rationale behind the rejection, that this person is not further discriminated against, and I'd ask for your support.
Mr. President.
Thank you, Mr. Chair. We've been down this road before. Ask for a no vote.
Seeing no further discussion, the question before us is the adoption of Amendment L003. All those in favor signify by saying aye. Aye. All those opposed say no. No. The noes have it. L003 is lost. There is another amendment on the desk. Mr. Carpenter, please read Amendment L004.
Amendment L004 to Senate Bill 40.
Senator Fields.
Thank you, Mr. Chair. I move L004.
Please proceed.
Thank you. Members, what L004 would do, we've heard about a lot about the second time, a second look, giving us the opportunity to be reflectful and thoughtful when the color of an individual is considered. So basically, that's what this does. Race discrimination is against the law. We all know that. It's illegal to discriminate against any person because of their race, color, national or ethnic orientation, or immigration status. So that's what this amendment will do. We heard last week about my colleagues are not evil. I believe that. Someone came up here and said that there was this thinking that just because I'm talking about race, or we're talking about color, or we're talking about discrimination, that there's a sense that we believe that some of my colleagues may have a hardened heart, I think someone said. And that's just not my belief. I don't believe that's the case. The reason I'm offering this amendment is because I am an African American woman, and I can't bury my past. And because I'm black, I have to carry on the burdens of my past. That's real. I didn't get an opportunity to define my race and who I am. So just because I'm up here talking about race and color doesn't dismiss who you are. And you shouldn't dismiss who I am because I'm talking about the color of my skin. There were times when blacks didn't have the right to read. We were considered property. And because of those historical past issues, we have rights that are in place to protect the color of our skins and all the other protective class. It's okay for us to talk about those things with you all thinking that I'm not trying to demean you. It's not about that. I'm carrying on the legacy and the burden of what it's like to be black. And far too often, that has caused me to be discriminated against. The majority of the people in this chamber are not out against to harm African Americans or any of the protective class. But what this amendment will do, it would cause us to pause. It would cause us to pause just a little bit to make sure that we're not having any adverse impact on protected classes. That does not gut this bill. That just celebrates the civil rights that we all have to be protected as human beings. So I urge an aye vote on this amendment, L004.
Is there any other discussion? Mr. President.
Thank you, Mr. Chair. And again, this is about granting the governor additional power within the Senate's confirmation power from the Constitution. This is not about protecting certain classes, races, color, or anything else. It's about granting the governor more power, and so I'd ask for a no vote.
Seeing no further discussion, the question before us is the adoption of Amendment L004. All those in favor signify by saying aye. Aye. All those opposed say no. No. The noes have it. L004 is lost. Mr. Carpenter, please read Amendment L010.
Amendment L010 to Senate Bill 43.
Senator Todd.
Thank you, Mr. Chair, and good morning, colleagues. Happy Monday. I move L010.
Please proceed.
Thank you. Again, we've talked a lot about different reasons for rejection of candidates. We know that there is great scrutiny from the department to come up with good candidates, but sometimes they are shunned and they are rejected. And one of the reasons I want to make sure that we are not rejecting a very capable candidate to serve on a board or commission is due to discrimination against the individual's disability. Now, that disability could include their speech, it could be a visual disability, it could be a physical disability. I know there have been several people who have been very instrumental in changing my way of thinking that are physically disabled and challenged here at the Capitol and would most definitely serve well on any committee, but I think sometimes that is looked upon as a distraction or maybe making it more difficult for them to serve, and I would want to make sure that we are not keeping someone from being able to serve on a committee or a commission or have an appointment based on that disability. I urge an aye vote on L010.
Mr. President.
Thank you, Mr. Chair. Again, I'd ask for a no vote.
Seeing no further discussion, the question before us is the adoption of Amendment L010. All those in favor signify by saying aye. Aye. All those opposed say no. No. The noes have it. L010 is lost. Mr. Carpenter, please read Amendment L006.
Amendment L006 to Senate.
Senator Fields. Oh, I'm sorry, Senator Finberg. Read the wrong amendment.
Thank you, Mr. Chair. I move L006.
Please proceed.
Thank you, Mr. Chair. I hear and understand some of the pushback on some of the previous amendments, but surely we can agree on this one. This one simply says that if the governor feels the rejection was due to the individual's religion, then the governor shall be able to resubmit that name for reconsideration. And I'm certain the bill sponsor would agree with me on this one. And that's all I have to say about that. Thank you, Mr. Chair.
Mr. President.
Thank you, Mr. Chair. And I suppose if this was actually about the freedom of religion, then we could have that debate, but this is still about the governor and ceding power to him. I ask for a no vote.
Seeing no further discussion, the question before us is the adoption of L006. All those in favor signify by saying aye. Aye. All those opposed say no. No. The noes have it. L006 is lost. It appears another amendment is on the desk. Mr. Carpenter, please read Amendment L002.
Amendment L002.
Senator Kerr.
Thank you, Mr. Chair. I move L002.
Please proceed.
Thank you, Mr. Chair. L002 is a protection for people being appointed based upon their sex. And as we look back through the history of our state and society in general, certainly we have come a long way from, and in fact, Colorado has a history of being amazingly open and progressive when it comes to women serving in the legislature and serving in elective office, and therefore also serving in these appointed roles. As I'm sure all of you know, Colorado was the first state to have an elected female in office. And I'm not sure if she was a Republican or a Democrat. I'm hearing that she was a Republican, and I think that shows that Colorado has been pretty progressive. And in fact, if you look at the number of women serving in the state legislature in Colorado today, one would think that there would be no issues around this. However, please remember that there are 35 Senate seats, and doing some quick little back of the napkin math, it seems to me that each of our Senate seats have been elected approximately 30 to 35 times. That means there are probably over 1,000 senators that have come and gone through this chamber over the years. Are you willing to bet that not one or not a group of those senators has ever had some bias against people of a different sex? So if you are willing to bet that, then you probably want to vote no on this. But if you want to make sure that no person, male or female, is discriminated against based upon their sex, please vote aye on L002. Thank you.
Mr. President.
Thank you, Mr. Chair. And I will ask for a no vote on this. It still comes back to the same issue. But I would thank the amendment sponsor for the history and noting that the first female elected to the legislature here was a Republican. And the very fact that we have such a rich history, at least in the political realm and in so many other realms in Colorado, I think argues actually against the necessity of this amendment. So I would ask for a no vote.
Seeing no further discussion, the question before us is the adoption of L002. All those in favor signify by saying aye. Aye. All those opposed say no. No. The noes have it. L002 is lost. Seeing no further discussion, the question before us is the adoption of Senate Bill 43. All those in favor signify by saying Senator Kagan.
On the bill, Mr. Chairman, I would just remind members before we go ahead and vote on this bill of what the current law says and what the bill would require, because they're very different. Under current law, if a person is rejected by the Senate for a nomination, under current law, the governor can make that same nomination a second or a third or a fourth or a fifth time, as many times as the governor deems appropriate, for reconsideration. That is the governor's current power. And the Senate has the power to reject that nomination time and again, and the governor has the right to make the nomination time and again. Under this bill, the governor would only be able to make the nomination the one time. The one time. And what this bill would say is not just the one time, but if the governor makes a finding that the nomination may have been rejected on an impermissible ground, the governor can say to the Senate, look at this a second time. Only a second time. That is an eminently reasonable accommodation of the competing interests in the nomination process. And I urge an aye vote. Sorry. And therefore, I urge a no vote on the bill.
Senator Kagan.
Just finishing up my speech, Mr. Chair.
Senator Donovan.
Thank you, Mr. Chair. Over 2 days now, we've had some discussion on the impacts of this bill and how it could be played out if go into effect. From citing, how this might be able to be interpreted to certain individual groups of people, but also we've highlighted that the consequences of the vote that is pondered by this legislation is quite significant, including that the rejected individual is deemed legally unfit. That's quite a significant label to earn as a citizen of Colorado, and also ineligible to hold office for a period of time. That is also quite a significant label to earn as a citizen of Colorado, and I think would not only impact what you're allowed or not allowed to do in this building, but would also impact your reputation in your community. I mean, if you are deemed legally unfit, and that is run as a news article in your community, I feel like that has significant impacts on your long-term reputation, and also this concept of just being able to be rejected by a vote also is quite a burdensome label to be placed upon a citizen. So therefore, I would like to move Amendment L016.
There is an amendment on the desk. Mr. Carpenter, please read Amendment L016.
Amendment L016.
Senator Donovan.
Thank you, Mr. Chair.
Now you have to move it.
Thank you, Mr. Chair. I move L016.
Thank you, Senator. Please proceed.
L016 says that a Senate rejects a nomination only if 2/3 of the members of the Senate vote on that. So this rejection would require a 2/3 vote because of the significance of the message that this would send. Let me highlight what this would also mean, and I think this is an important step to consider in this process. With this amendment, it also requires that this decision would come to the floor for consideration. Otherwise, we could see an individual being rejected by a 5-person committee, which could be done by 3 members of the Senate. So without this amendment requiring a 2/3 vote and requiring it, therefore, to come to the floor, we could have 3 people in this body decide to reject an individual and then have them deemed legally unfit. I ask for your support on L016. Because of the weightiness of the consequences of this bill, I think that it should be a consideration by all members of this esteemed body and carry the gravity of a 2/3 weight to deem someone legally unfit. Thank you for your attention.
Mr. President.
Thank you, Mr. Chair. Several things. I will speak to the amendment first. Factually wrong statement about whether a committee can reject a nominee. There's 3 people in a committee cannot reject a nomination. They recommend or they don't recommend. But every nominee comes to the floor after a hearing. Everyone, even if they lose 0 to 5 or 0 to 7 or 0 to whatever, they come to this chamber for an up and down vote. That's a fact. The idea of a 2/3, we're talking about large changes. One senator came up and mentioned sweeping changes that this is creating. It's actually not. It's actually codifying practice in the state of Colorado throughout its entire history. And this amendment only further changes that practice by moving it to a 2/3 vote. The Senate, at every level, including the United States Senate, can reject upon a majority vote. I reject this amendment and ask for a no vote.
Seeing no further discussion, the question before us is adoption of Amendment L016. All those in favor signify by saying aye. Aye. All those opposed say no. The noes have it. L016 has failed. Back to the bill. Senator Guzman.
Thank you, Mr. Chair. Members, we've been discussing this very important bill, and I think I said the other day that I know, and I'm sure, and the Constitution says, that the Senate is indeed responsible and has the jurisdiction over these decisions, that has had this role not only locally in state government, but at the federal government for years, that the Senate has always been given that right. And I do not question that it is the right of the Senate to make the decision, to bring the vote through committee to the floor in terms of those who are nominated. My only concern, and the concern of our caucus, has been what happens when politics play into these decisions. And we know that politics is hard to prove. I just want to mention a couple of things that have happened in one committee regarding the nomination of new possible committee members and the nominations to reaffirm 2 members. It happened in the Education Committee. The chairman brings up the issue of fetal tissue. This is in the Education Committee. This is not in Human Services or the Committee on State Affairs. This is in the Education Committee. The chairman brings up the issue of fetal tissue to the committee and to the appointees. Another senator brings up and asks about 224 purchases from that university of fetal tissue from Advanced Bioscience Resources. This is in the Education Committee that is being asked to appoint people to a board, an education board at the higher education level. Another senator says to those appointees or those who are requesting, will you oppose the start or resumption of any research program associated with the university which involves fetal tissue from aborted babies? He asked this of each of the three. My friends, this is the issue we are trying to make. Politics comes into play, and we are just concerned that the Senate operate in the very best possible, the very best process when we are given the right and have the responsibility to nominate and or refuse to nominate someone for that the governor has requested that we look at. It is our responsibility. It is not the place for political decisions, politics to take place. It is about how are these folks prepared? Are they people who are interested and can devote their times to their work? My friends, I'm here to share with you this, to say there is an issue about how we make sure that we as the Senate deal with these issues in the most professional way. I urge a no vote on this bill.
Seeing no further discussion, the question before us is the adoption of Senate Bill 43. All those in favor signify by saying aye. All those opposed say no. The ayes have it. Senate Bill 43 is adopted. Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee rise and report.
Question before us is for the committee to rise and report. All those in favor signify by saying aye. All those opposed say no. The ayes have it. The committee will rise and report.
Senate will come back to order. Senator Sonnenberg.
Thank you, Mr. President. Your committee has met and had several bills under consideration. Mr. Carpenter, would you please read the report?
Mr. President, your committee will hold begs leave to report that under consideration the following attached bills pending second reading thereof makes following recommendations are on. Senate Bill 43 is amended, passed second reading order, gross placed on the calendar for third reading and final passage. House Bill 1253 is amended, passed second reading order, revised, placed on the calendar for third reading and final passage. Senate Bill 204 laid over until 4/2018, retaining its place on the calendar. Senate Bill 206 referred to the Committee on Appropriations.
Senator Sonnenberg.
Thank you, Mr. President. I move for the adoption of the report.
Motion for the body is the adoption of the report to the Committee of the Whole. There are amendments on the desk. Please add Senator Marble to the roll. Mr. Carpenter, would you please read Committee of the Whole Amendment 2 by Senator Kagan?
Committee of the Whole Amendment 002 to Senate Bill 43. Senator Kagan moved to amend the report of Committee of the Whole to show the following Kagan floor amendment to L001 to Senate Bill 43 did pass. Amendment part of Bill page 4, line 16, strike notwithstanding and substitute except as otherwise provided in subsection 3A of this section and notwithstanding.
Oh, Senator Kagan.
Mr. President, I move Committee of the Whole Amendment 2.
Please to the amendment.
Thank you, Mr. President. Committee of the Whole Amendment 2 suggests that, or would show that L001 did pass. What this means is, members, that instead of passing Senate Bill 43 in a form that would give the governor no authority under any circumstances to resubmit a nomination unless it was a new General Assembly. Instead of giving that governor no authority to resubmit, It gives the governor the opportunity to resubmit in the limited circumstance where the governor asks the Senate to take another look because the governor believes that the nomination may have been rejected on an improper ground. And it says that the governor may cause a second look to be taken at that nomination, rather than no second look ever being taken, regardless of what the basis may or may not have been for the nomination in the first place. So we are, with Senate Bill 43, giving the Senate a very sweeping power to bar a second look, or a third look, or a fourth look, or any other additional looks in the same General Assembly. And Senate Bill and Amendment 1 would have just said, no, you can have one second look if there was an improper basis, possibly, for the first rejection. That is an eminently reasonable way to preserve the deliberative nature of the Senate's nomination processes. And I urge and I vote on Committee of the Whole Amendment 2 to Senate Bill 43.
Senator Gardner.
Thank you, Mr. President. Members, I urge a no vote. This amendment, as Cow Amendment and the underlying amendment, I'm going to accept that they're well intended, but the fact of the matter is it's a blank check to the first floor to override the intent of Senate Bill 43. All the governor has to do is say, well, I think the reason for the rejection of the nomination may have been that. Members, there are 35 of us, and there are at least that many motivations, and those motivations are our own. I would not want to think for a moment that any of you would vote to reject a nomination for any of these impermissible and discriminatory bases. But one can surmise about your motivation all they want to, and this invites that sort of surmise. Senate Bill 43 is intended to require the executive branch to adhere to the action of the Senate in confirming or rejecting a nomination. That's all there is to it. I ask for no vote on this cow.
Is there any further discussion? Any further discussion, Senator Court?
Thank you, Mr. President. Well, members, we know that discriminatory comments surface in committee hearings. In fact, as I pointed out to you when we debated this last week, and I brought an amendment about age, our current treasurer running for governor brought up that we don't need any more gray hairs on a given committee. Those were his words. It's in the public record. That is age discrimination. That is clearly making a comment about age and in relationship to a commission nominee. Now, that wasn't one of us, but that certainly is a public official who was blatantly expressing ageism. So I think it's really important that we acknowledge that if there is a concern that that might have existed in any form, any kind of bias in any of our deliberations, the governor should be able to send it back to us. And so I urge a yes vote on this Committee of the Whole amendment. Thank you.
Senator Kerr.
Thank you, Mr. President. I rise in support of Committee of the Whole Amendment 002. And specifically, I'd like to go to the first protected status, an individual's sex. And as it specifically says, that the governor believes the Senate may have rejected the prior nomination of the individual for appointment to the office on the basis of the individual's sex, race, color, national origin. And I bring this up because I have seen this here in the Senate. As was mentioned a little while ago on second reading about a case that happened in the Education Committee where a subject was brought up. And I don't believe that the actual vote in the committee was mentioned. But in that committee, the individual asking the question then voted for one of the male nominees and voted against the female nominee, even though they had given substantially the same answer as to that didn't really have anything to do with their confirmation. So, you know, I brought up before that we've had probably somewhere close to 1,000 different senators go through the Senate over the years. You can see all their pictures out there in the lobby. You see all of our pictures in committee rooms. You see the senators who served decades, dozens of years, 100 years before we did. And to not adopt this Cow amendment basically means to say that you are saying that pretty much no senator ever brings any kind of bias with them when they serve here, and that that we are all completely pure of heart. And while I would say that the vast majority of us are here for the right reasons and try to be as fair as possible, I know for a fact that that is not always the case. There's another committee that I sat on, and I had actually forgotten about this until I was reading a report. It's called General Assembly 2.0, a transformational approach to legislative workplace culture. We all received this last Thursday or Friday on your desk, and I spent some time over the weekend going through it. And I actually found a piece in here that I remember witnessing. I actually remember being a part of. And this is it's on page 49. It's called Sexist Commentary and Behaviors. And it says, sexist behavior in the legislative workplace was referred to throughout the survey. Male legislators were identified as those most likely to make sexist comments, and remarks made during committee meeting was mentioned more than once. A, quote, culture of silence among women who do not report sexist behavior is believed to contribute to and embolden male legislators. One survey respondent reported an event where male committee members were, quote, bragging about the fact that their committee contained no women, while nonpartisan women were at the table taking minutes. This also says that locker room talk and sexism towards women is considered common. So when I come up and I say, you know, we should at least put some protections in place because sexist behavior could happen, and I believe has happened, that we need to take that seriously. Again, this amendment is talking about allowing the governor a second look, and that is it. Not the pretty much just blanket, go back, leave a confirmation alone where, that it is right now, but a second look based upon if there is evidence that a confirmation was denied based on these protected classes. I ask for an aye vote on L002.
Any further discussion? Seeing none, the motion for the body is the adoption of Committee of the Whole Amendment 2 to Senate Bill 43. Are there any no votes? Senator Cook, Senator Neville, Senator Hill, Senator Crowder, Senator Marble, Senator Baumgardner, Senator Sonnenberg, Senator Holbert, Senator Lundberg, Senator Lambert, Senator Martinez-Humenick, Senator Tate, Senator Smallwood, Senator Priola, Senator Scott, Senator Gardner, Senator Coram. And please add the president. With 16 ayes, 18 noes, 0 absent, 1 excused. Committee of the Whole Amendment 2 is lost. Mr. Carpenter, would you please read Committee of the Whole Amendment 3 by Senator Court?
Committee of the Whole Amendment 003 to Senate Bill 43. Senator Court moved to amend the report of Committee of the Whole. Show the following court floor amendment L007 to Senate Bill 43 did pass. Amendment printed bill page 4.
I withdraw 003. Thank you.
Committee of the Whole Amendment 3 is withdrawn. Mr. Carpenter, would you please read Committee of the Whole Amendment 4?
Committee of the Whole Amendment 004 to Senate Bill 43. Senator Zinzinger moved to amend the report of the Committee of the Whole. Show the following Zinzinger floor amendment L017 to Senate Bill 43 did pass. Amendment printed bill page 4, line 20, strike legally.
Senator Zinzinger.
I move Cow Amendment 004.
To the amendment.
Again, members, this is an extremely simple amendment that says that we were wiser when we debated this discussion about striking the term legally unfit. If you do a simple Google search about legally unfit, what's going to come up are cases where people were deemed legally unfit to parent, to have a power of attorney, to vote, to stand trial. This has consequences for people's employment. It could have consequences for people's future political careers. These are people, appointees that we are looking to fill a board or a commission to do the people's work, to assist us in our goals of governing our state. They're all across the board. They're from the Water Commission, boards of higher ed. They monitor ditches. They help with any number of different issues that we deal with where we want a citizen perspective on it. And the intent of this legislation, I understand, is about a separation of powers, and I understand that this is about rejecting a particular applicant that we feel is unfit or unqualified. And I get that. And this amendment doesn't change that. It simply says that we might be overreaching by stating that this person is deemed legally unfit by this body, and that legally unfit characterization could follow this person forever. It could be brought up in a custody case. It could be brought up in an employment interview. It could be brought up in any number of situations. And I know that that is not the intent of this legislation, and so we can fix it. We can fix it very easily just by striking that one word. And it doesn't change anything. It simply says unfit or unqualified or ineligible, which is kind of the point of the legislation. So I would urge members to reconsider the conversation that we had earlier and to recognize that this is not what we mean to do here today. We don't mean to deem people legally unfit forever simply because they are unqualified or unfit to serve on a board or commission. And I would urge an aye vote on Committee of the Whole Amendment 4.
Senator Gardner.
Thank you. Well, I'm first of all wondering whether if this cow were to actually be adopted, whether the senator from Jefferson County, the proponent of this amendment, would suddenly be a yes on the bill, but I doubt that very seriously. The reality is that if you don't say legally unfit, it begs the question of whether, does it mean they're morally unfit? Because that's not what we mean. It is a legal disqualification. It's a legal qualification for a period of time. Therefore, it's necessary to put the word legally there, because to leave it out implies far more and far worse than the senator from Jefferson County wants herself. I ask for a no vote.
Is there any further discussion? Seeing none, the motion before the body is the adoption of the Committee of the Whole Amendment 4. Are there any no votes? Senator Baumgardner, Senator Cook, Majority Leader Holbert, Senator Hill, Senator Crowder, Senator Marble, Senator Sonnenberg, Senator Neville, Senator Lambert, Senator Lundberg, Senator Martinez-Humenick, Senator Coram, Senator Tate, Senator Smallwood, Senator Priola, Senator Gardner, Senator Scott. Please add the President. 16 ayes, 18 noes, 0 absent, 1 excused. Committee of the Whole Amendment 4 is lost. Mr. Carpenter, would you please read Committee of the Whole Amendment 5 by Senator Todd?
Committee of the Whole Amendment 005, December 4.
Senator Todd.
Thank you, Mr. President, and I move Cal 005.
To the amendment.
Thank you. This amendment is speaking to what I referenced earlier in terms of discrimination based on disabilities. And so, again, I think hearing impaired is probably one of the reasons for a disability that could be classified: blindness, physical disabilities, being confined to a wheelchair, not able to have the mobility. Any and all of those should most certainly be reasons to not disqualify. And so, again, this COW is saying that L010 did pass, and I would ask for an aye vote on COW number 5. Thank you.
Is there any further discussion? Seeing Senator Gardner.
Second verse, same as the first. I ask for a no vote.
Is there any further discussion? Seeing none, the motion for the body is the adoption of Committee of the Whole Amendment 5. Are there any no votes? Senator Cook, Senator Neville, Majority Leader Holbert, Senator Baumgardner, Senator Hill, Senator Crowder, Senator Marble, Senator Sonnenberg, Senator Gardner, Senator Lambert, Senator Lundberg, Senator Tate, Senator Smallwood, Senator Martinez-Humenick, Senator Priola, Senator Scott, Senator Coram. Please add the President. 16 ayes, 18 noes, 0 absent, 1 excused. Committee of the Whole Amendment 5 is lost. Mr. Carpenter, please read Committee of the Whole Amendment 6 with Senator Garcia.
Committee of the Whole Amendment 006, Senate Bill 43. Senator Garcia moves.
Senator Garcia. Go ahead.
Thank you, Mr. President. I move Amendment the Cow Committee Amendment W006.
To the amendment.
Thank you, Mr. President. Members, we've had a lot of important conversations around Senate Bill 43. I think we've seen some discouraging inaction today by not allowing some of those other amendments as legally imply that you are not legally fit to serve. But I think one of the things that most concerns me is not having a provision that would ensure that one could not be disqualified based on an individual status as a disabled veteran. I'd ask that when that amendment was previously considered, that you now, given the chance that we not reject this amendment, I ask for an aye vote.
Senator Gardner.
Thank you, Mr. President. Members, I ask for a no vote. I ask for a no vote because I refuse to believe that anyone serving this chamber now or in the future would ever do this. It is just astounding to me that one would think that we need to pass a statute to do this, but it is all part of the fabric of this set of Committee of the Whole amendments to raise these issues. Fair enough, I suppose, but I ask for a no vote.
Senator Kagan.
Thank you, members. And I rise to support this Committee of the Whole amendment because I want to just point out that it is far from beyond the realm of possibility that members of the Senate would disadvantage a person because of their disabled veteran status. Now, at first, it may seem to some that who would ever do that? But if you look into the lives of disabled veterans, you will see plenty of occasions where they are discriminated against on the basis of the fact that they are disabled veterans. In housing, there are some landlords who just don't want to deal with veterans on because of the fear that they might have PTSD or because of the fear that they may have gone through so much that they have may become troublesome. In the field of employment, you often get the same thing, where employers think, well, this man or woman has been through a lot, and I fear that it may have affected them in ways that I do not yet understand or see, but I don't want to have to deal with that, and therefore they err on the side of rejection for employment. And disabled veterans have come to me and said that they are having trouble because of their disabled veteran status in getting fair access to employment and to housing. And it is not fanciful at all to think that a disabled veteran would meet with some resistance in a Senate committee that was considering an appointment to a board or a commission, and that a senator may well say that and give the governor the indication that the rejection was based in part, perhaps, on their disabled veteran status. And think for a moment if you are seriously disfigured, which makes some people uncomfortable, and you are being considered. And you're seriously disfigured as a result of an IED in a theater of war. And then you come before a committee, and some committee member says in discussion of the recommendation, really, a guy that looks like that, do you really want him or her, a person that looks like that, to be serving on a board on a regular basis? I don't think so. And that is not a fanciful suggestion. Our disabled veterans do meet with impediments. And if you have disabled veterans in your community, you may know that from them having contacted you. I certainly know that from them having contacted me. And so this is far from a fanciful thought that this may occur. This does occur. And these disabled veterans who want to serve should not have impediments placed in their place. And when they are placed in their way, they should get a second look if that was part of the consideration. That's why I urge and I vote on this Committee of the Whole amendment.
Senator Lundberg.
Thank you, Mr. President. Mr. President, I ask for a no vote on this amendment. I couldn't help but come down and speak to it because I don't consider this to be a possible scenario that this Senate is capable of, nor any Senate that I've ever seen. And I think of a gentleman I know who was badly disfigured. As a matter of fact, he was the closest survivor to the impact on the Pentagon in 9/11. He actually serves in the Texas State Senate today, Senator Birdwell. And he was burned over 70% of his body. And the first time I ever met him, his face was very obvious. And I want to tell you that that was a mark of distinction and honor and courage. And I find it utterly absurd that it would be construed to be anything but that if you're a disabled veteran. And to even suggest that a senator in the state of Colorado could somehow flip that on its head and consider that an impediment, to me is absurd and embarrassing and an insult. Vote no.
Senator Garcia.
Thank you, Mr. President. Well, again, I'd renew my request for an aye vote. And I think it's interesting to note that the debate has shifted. And when we talked about this a couple days ago, the question was whether or not we were giving more authority to the governor, or whether or not the Senate should have more responsibility. And now you hear some members saying, well, you know, I could never see a member of the Senate acting that way. And I would agree to a certain extent with the members we currently have here. The members like the good senator from El Paso County or the senator from Berthoud who may not have that bias. But I would ask you, members, to reflect on why would you think that there are so many protections for veterans to protect against these types of scenarios if it didn't happen in the first place? If it didn't happen in the first place, why do we have these types of protections based on housing and veteran status and service and disability status? Why would we have these protections if it weren't happening in the first place? Now, I won't claim to be an expert on many of the filing processes or claims, but I will tell you I served 6 years in Iraq, or in the Marine Corps, and I served in Iraq in 2003, and I have heard from some veterans who say they have experienced this. What you're saying is that it is almost impossible to imagine that there are no veterans who could experience this. Impossible. I would just say that's just wrong. It's wrong, and it's irresponsible of this body not to accept an amendment like this. It's a protection. If it's just a protection, I'd ask, why aren't we being veterans advocates and just add the protection for them? I'd ask for an aye vote.
Mr. President.
Thank you. I'd ask for a no vote. Colleagues, this is about the governor. Since the previous speaker said the debate has shifted, this is about granting him more authority. So let's get back to it. Every single one of these amendments is shifting authority, shifting constitutional power from this body to the first floor. That's what these are about. It's not about these last couple or three words in each of these amendments. I was asked the other day whether or not I had consulted the first floor on drafting this bill. Guess what? I've talked to the first floor more about this bill than I guarantee anyone else in this chamber put together has. They don't like it. I can't understand why. They don't like it because it is actually putting them back in the place that they belong as the executive branch. That is what the bill does. Historically, no governor has ever ignored the Senate, ever, when they rejected a nominee. That's what this bill does. This gives even more power to the governor. When somebody asked me whether or not I had talked to the governor, talked to the first floor, I wonder if anybody talked to our 70% disabled veteran in this chamber before they drafted this amendment. I'd ask for a no vote.
Seeing no further discussion, the question before us is the adoption of Cal Amendment 007. Are there any 006? Got the wrong one. Are there any no votes? Senator Hill, Senator Cook, Senator Crowder, Senator Baumgardner, Senator Marble, Majority Leader Holbert, Senator Lundberg, Senator Martinez-Humanic, Senator Lambert, Senator Tate, Senator Smallwood, Senator Priola, Senator Gardner, Senator Scott, Senator Coram, Senator Neville. Mr. President, please add the president. With 16 ayes, 18 noes, 0 absent, 1 excused, Amendment 6 is lost. Mr. Carpenter, please read amendment to the Cal 8.
Committee of the Whole Amendment 008, Senate Bill 43.
Senator Kerr.
Thank you, Mr. President. I move Committee of the Whole Amendment 8.
To the amendment.
Thank you, Mr. President. This is the bill. This is not an amendment. This is the bill. And sometimes we make funny remarks about the hearing of the chair or anything like that. But this is just an amendment to say that this bill did not pass. And this is your chance to take all of the discussions, all of the arguments into place around this bill and decide whether or not you think this bill is worth sending on through the process. We've heard a lot of debate on various individual protected classes and whether or not we, as the 35 of us in this current Senate, could possibly have any bias towards any protected class or not. And I've tried to go back a little bit in history and give folks context over senators, Colorado state senators throughout history, and whether or not there's any chance of them having any of these biases. And I think it's pretty clear. I gave some examples of where I personally have seen bias, sexist behavior in committees that I've served on and been sitting in, and that could be my bias. That could be my opinion, except the example I read out of this report about the legislative workplace culture, talking about sexist behavior and using an example that I have seen in a committee before. We all have biases. We don't always realize exactly what our biases are or not. The amendments that we've attempted to run would give some protection to folks who are otherwise in protected classes when they apply for a job with the state of Colorado and most other businesses throughout Colorado. We have asked that the governor include as part of the nomination statement that the governor believes the Senate may have rejected, doesn't say did, doesn't call out anyone individually, just says the Senate may have rejected the prior nomination of the individual for appointment to the office on the basis of the individual's sex, race, color, national origin, religion, age, sexual orientation, gender or gender identity, or disability. If you can look in your own heart and say that you have never had any bias at all against anybody for any of those reasons, more power to you. I'll be the first to admit here that I've made mistakes in my life, and I've let my biases come out at different times. I try as hard as I can not to, but I know that has happened. I think one of the points on this bill, we go back, look at our discussion from last week, and on the one hand, I forget the exact term, but what is crawling through your minds to come up with the idea that any of us could ever have these impure thoughts? And there was almost the opposite comment that none of us, it's not believed that any of us have any malice in our hearts. And like everything else in life, I think the truth is somewhere in between. If you believe that life and our work here in the Senate sometimes deals in the gray, it's not black and white, but deals in the gray, and sometimes we have to make decisions and we take votes based upon sometimes our own personal biases and trying to overcome those, then this is a bill that allows the governor a second time to look at that and gives us each individually some time for some introspection as to why we voted the way we did. I don't believe that this is a huge power shift between the branches. I don't think I have ever argued for a bill that would take away the power of the legislature or argued against a bill that would do the same thing. But I don't see this bill as being a major shift in the balance of power between the branches, but I do think that there are some basic protections we could put in place here. I ask for an aye vote on Committee of the Whole Amendment 8.
Senator Gardner.
Thank you, Mr. President. Well, I thank the senator from Lakewood for bringing this cow amendment. I ask for a no vote, but I thank him for bringing it because it is a straightforward Committee of the Whole amendment to say that the bill did not pass. All of the implications of the amendments, which the senator from Lakewood discussed, are frankly implications and assertions that this chamber might act inappropriately, or that, really that the chamber as a whole would act inappropriately. But what this bill is about none of that. And it isn't about a shift in power between the two branches. It is about a restoration. Because as the president said earlier, no governor in memory has done what was recently done, which is, and I want to be careful about how I say this, but it was in a political way, a poke in the eye of the Senate with a stick. Now, it is the nature of government in America and a tripartite system that there will always be tension between the executive and the legislative. So when I say that, it's not personal to the office holder. It's just simply the fact that the Senate rejected a nomination, should have been respected, and it was not. And the Constitution and the statute seem to be ambiguous about what my expectation as a senator rejecting a nomination was. This bill makes clear what our expectation is. Now, the voting on the bill, the amendments, everything has been on a party line, and I understand how we in this chamber can fall into those things, but I've been around this block a few times. Before I was in the House, long before, was a party chairman, and I followed the General Assembly and its workings and who was up and who was down and who was up and who was down on the first floor for 30-plus years. And occasionally I run across a statute that says appointments will be made for some particular body or something, and it'll all be done by the leadership in this chamber and that chamber. And I have been in the General Assembly when this chamber and that chamber were controlled by a party different than my own, the other party. And I've thought, why did they do that? Why did they do that? Why did they do that in 1985 or 86? Well, I know why they did that in 1985 or 86 or 90 or 92, because Republicans thought that they would be in charge of everything forever. And with respect to those fine members, they should have thought maybe they won't be. And I've seen other things in statutes over the years that were like, why was the executive branch given that power that way, sort of for all time, absent statutory change? And the answer was because one party or the other thought they were going to control the first floor forever. Well, we're not, none of us. I think the one thing we do know over those 30 years that I have watched this process and known the people who served in this chamber and the other chamber and been a part of that chamber and this chamber, inevitably, in ways that we cannot imagine, in ways that we cannot predict, one party or the other, or maybe a party we haven't even thought of yet, will be in the majority, will hold the office on the first floor. And my friends on the left of the chamber, my right, if you vote this bill down today, if you vote no today, if you send this over to, if it passes and you send it over to the other chamber and ask your colleagues of your party to pass this, I suggest to you that in 10 years you may wish you had voted differently and asked for something differently. Because this is not about party, this is about the power of the legislature versus the power of the executive. And we cannot predict who, but we can, I hope, count on the fact that there will be an executive and there will be a legislative branch. And by the way, for those of you who have been around long enough that this chamber, that chamber, and the first floor were in the control of one party or the other, that's not so agreeable either. In fact, sometimes worse. It's great for your, it's probably great for your party and great for your principles, but in terms of the relationship between executive and legislative, I think it is often more strained. This bill is not about party. It is not about discrimination. It is not about anything other than the balance of power and the proper role of the Senate, and the Senate has constitutionally been given the responsibility to accept, that is, confirm, or reject nominations by the executive branch. We are constitutionally given that responsibility. And whoever we may be this term or next term or 5 terms from now, that responsibility needs to be discharged in a way that it will be respected. And all that this bill is about is to ensure that this chamber, whoever is the president, whoever is in the majority, whoever sits in your seat, that their acceptance or rejection, and primarily their rejection of a nomination, will be respected by the executive branch and not overridden, ignored, pushed aside, because that is our constitutional responsibility. I ask for no vote on this cow.
Senator Zinzinger.
Thank you, Mr. President. I'd just like to correct the record. There was a comment that was made by our good senator from Colorado Springs that every single amendment that was run today was about a protected class. or about discrimination or about ageism or ableism or racism. And I'd like to say, no, in fact, not every amendment that was brought forward in that regard. That in fact, I brought forward an amendment that was very critical to the bill, that didn't change the intent of the bill, that didn't imply racism or sexism or discrimination. It was a simple amendment that merely said, let's not overreach here. Let's not try and have any kind of unintended consequences because of the language that we're choosing to use in this amendment, in this bill. That's all. It wasn't politically motivated. It was saying that the actual consequences of using that term, that particular term, legally unfit, could have unintended consequences. That is a term that could follow somebody for the rest of their lives because it has been deemed by this body, a pretty prestigious body, that could have real consequences for their lives beyond what they are what they're being appointed to. That's all. It didn't change the intent of the legislation. And in fact, I thought it could have actually made it better by making sure that we were not overreaching and that we weren't trying to deem a person legally unfit forever in all regards of things in their lives. So I'd just like to say that I'd like to point out and correct the record that that is not the case, that there were some amendments that I think were pretty darn serious and not politically motivated, and I take exception to that.
Is there any further discussion? Seeing none, the motion before the body is the adoption of Committee of the Whole Amendment 8. Are there any no votes? Majority Leader Holbert, Senator Scott, Senator Smallwood, Senator Tate, Senator Lambert, Senator Martinez-Humenick, Senator Gardner, Senator Coram, Senator Cook, Senator Hill, Senator Crowder, Senator Neville, Senator Marble, Senator Baumgardner, Senator Lundberg, Senator Sonnenberg, Senator Priola, Senator Lambert. Please add the President. 16 ayes, 18 noes, 0 absent, 1 excused. Committee of the Whole Amendment 8 is lost. Motion before the body is the adoption of the Committee of the Whole report. Are there any no votes? With 34 ayes, 0 noes, 0 absent, 1 excused, Committee of the Whole report is adopted. Senate Bill 43 is amended, passed on second reading, ordered engrossed and placed on the calendar for third reading and final passage. House Bill 1253 is amended, passed on second reading, ordered revised and placed on the calendar for third reading and final passage. Senate Bill 204 laid over until 4/2018, retaining its place on the calendar. Senate Bill 206 referred to the Committee on Appropriations. Signing of bills.
The President has signed Senate Bill 1187, 161, and 162.
Delivered to the Governor.
To the Governor for signature on Monday, April 9th. To the Governor for signature on Monday, April 9th, 2018, at 8:53 a.m. Senate Bill 1187, 161, 162, and 170.
Announcements. Senator Kafalis.
Thank you, Mr. President. Good morning, colleagues. Two announcements, if you will. First of all, at noon today, we have the final, I believe it's the final session of the Colorado Children's Caucus. from 12 to 1:10 p.m. There'll be two topics presented, and that is in SCR 357. The second announcement is regarding tomorrow morning from 8 to 9 a.m. The Family Resource Center Association is hosting a breakfast tomorrow outside the old Supreme Court chambers from 8 to 9 a.m. I invite you to meet the Family Center directors and some of the families they serve. There are 29 family centers providing services to 30,000 families in 46 counties located throughout Colorado. The family centers help families connect with comprehensive, coordinated services to strengthen families and become self-reliant. The centers offer services based on the needs of the local community they serve. These services range from early childhood education, workforce development, nutrition, health and wellness, and adult education. Family centers are located throughout Colorado in cities and towns such as Aurora, Akron, Boulder, Conifer, Cortez, Canyon City, Carbondale, Delta, Denver, Divide, Fort Collins, Lafayette, Longmont, Fort Morgan, Rocky Ford, Silverthorne, Grand Junction, Colorado Springs, Durango, Pueblo, Granby, Alamosa, Akron, Telluride, Nucla, Yuma, and Walsenburg. Please stop by tomorrow, 8 a.m., outside the old Supreme Court chambers. Thank you.
Senator Tate.
Thank you, Mr. President. This is a scheduling item. Today in the Senate Committee on Business and Labor, we will not be hearing Senate Bill 217. That will be rescheduled for Wednesday at the end of the Wednesday calendar. Thank you.
Senator Lundberg.
Thank you, Mr. President. Members of Appropriations Committee, we are adding Senate Bill 206 to the calendar for tomorrow morning.
206.
Senator Lambert.
That was 206, yes. JBC will not be meeting today as scheduled.
Any further announcements? Message from the House.
The House has passed on third reading, transmitted to the Rise of Statutes, House Bill 1300, 1241. The House has passed on third reading, transmitted to the Rise of Statutes, House Bill 1295, 1157, 1020, 1174, 1070. Minutes printed in the House Journal, April 6, 2018. The House has passed on third reading, returns herewith Senate Bill 188 and 14. The House has passed on third reading and transmitted to the Rise of Statutes, Senate Bill 187, 179, 154, 180, 146. Minutes printed in the House Journal, April 6, 2018. The House has voted to concur in the Senate amendments to House Bill 1282, 1326, 1339, 1259, and has repassed the bills as so amended. The House has voted not to concur in the Senate amendments to House Bill 1322 and requests that a conference committee be appointed. The Speaker has appointed Representatives Hamner, Chairman, Young, and Rankin as House conferees on the first conference committee on House Bill 1322. The bill is transmitted herewith. The House has voted to grant the House conferees on the first conference committee on House Bill 1322 to consider matters not at issue between the two houses. The House has voted not to concur in Senate amendments to House Bill 1329 and request that a conference committee be appointed. The Speaker has appointed Representative Hamner, Chairman, Young, and Rankin as House conferees on the first conference committee on House Bill 1329. The bill is transmitted herewith. The House has voted not to concur in the Senate amendments to House Bill 1338 and request that a conference committee be appointed. The Speaker has appointed Representatives Hamner, Chairman, Young, and Rankin as House conferees on the first conference committee on House Bill 1338. The bill is transmitted herewith. The House has voted not to concur in the Senate amendments to House Bill 1340 and request that a conference committee be appointed. The Speaker has appointed Representatives Hamner, Chairman, Young, and Rankin as House conferees on the first conference committee on House Bill 1340. The bill is transmitted herewith. The House has voted to grant the House conferees on the first conference committee on House Bill 1340 to consider matters not at issue between the two houses. The House voted to adhere to its position on House Bill 1237. The bill is transmitted herewith. The House has voted to recede from its position on Senate Bill 151 and has repassed the bill. The bill is returned herewith.
Majority Leader Holbert.
Thank you, Mr. President. A little advance heads up. Senate Bill 179, I think, was just in the report read by Mr. Carpenter, and there is a very good chance that Senate Bill 179 would be recalled to the House. It is missing an appropriation clause, and since it started here in the Senate and moved over to the second chamber, now that it has passed both chambers, it has been discovered that there should be an appropriations clause. So just a heads up, we will probably hear from the House that they're asking for that bill to come back, and that would allow House Appropriations to apply that Appropriations Committee report, the Appropriations Clause. We will leave the desk open today. I believe we'll have some more bills coming over from the House. You do not need to be here. And just another heads up, between now and May 8th at least, if not the 9th, we probably will be leaving the desk open during the day rather than adjourning in the morning just in case there's anything that comes over from the other chamber and we can get ahead of reading those reports across the desk and getting things onto the calendar. For that reason, Mr. President, I move the Senate adjourn until 1 p.m. today. Excuse me, I just contradicted myself. I withdraw that motion and move that the Senate recess until 1 p.m. today.
The motion is for the Senate to recess until 1 p.m. today. All those in favor say aye. All opposed, no. Ayes have it, and the Senate will stand in recess.